The Supreme Court said that this has to be permitted. It's a charter right of Canadians to have access to that. Our job was to make sure that there were proper safeguards. And I wished, and I worked constructively. I'm sure my colleagues, I know they did try to work constructively. And if we would have provided, excuse me, adequate safeguards for those that have a mental illness, if an individual with a mental illness does not have capacity to buy a cell phone contract, how could they be deemed to have capacity to commit to give permission to end their life prematurely? And so if there would have, in that's one example. Another one, I agree with Michael Cooper that the court clearly said it was an adult, a competent adult giving consent. And if that's just two examples, and if we heard time and time again from witnesses that there is no other regime where physicians or institutions are required to be involved with if it's against their conscience. And so if conscience rights would have been protected, there would not have been a dissenting report.
We're looking to ensure that we continue to take an empathetic approach, that we look to create balance in our approach that recognizes the autonomy of individuals, that recognizes the need to protect the vulnerable, that respects the conscious rights of medical practitioners. It's too early to say what is going to be in the legislation and what's not going to be in the legislation. What I can and will reiterate and assure is that we're going to have substantive discussions on this. We are going to move very quickly into cabinet so that my cabinet colleagues can consider all of these issues that are being raised and ensure that we engage broadly around these substantive fundamental questions about what is going to be or what's not going to be in the legislation.